You're on.
You just keep digging the hole deeper.
Here we go.
6 feet.
Okay,
We're done.
we're ready to go on the record?
Okay.
Okay. You good? Thank you. Okay. Okay. Good evening, everybody. Wanted to call to order the Monday, February 10th, 2025 special meeting of the Fair Rent Commission. As a call to order, I want to see if we can first begin with the approval of the minutes on the agenda item, which is the June 10th, 2024 minutes.
I move to accept the minutes as published.
Okay. Do we have a second? We do? Okay, second. Any discussion? Hearing none. All those in favor? Aye. The ayes have it, unanimous. Thank you. Minutes are approved. We have new business, case number 2024-06. Keisha Harper, 300 Cold Springs Road, apartment C609. Before we begin today, I just want to make note that the respondent in this case, Concierge, has submitted a letter. They indicated that they were not going to be able to attend today, either through counsel or through a personal representative, but they submitted a letter in response to the complaint. Kelly, has the claimant received a copy of this?
Yes.
Okay, all right. Just to lay some ground rules for you, as well as for the people watching this remotely. The Fair Rent Commission here in Rocky Hill was created under Connecticut General Statute 7-148B. It's a commission of limited jurisdiction. So we have been charged with reviewing complaints, dealing with rental conditions and charges in our town, in determining for guiding principles so that you know this in terms of presenting your case here today, in determining whether a rental charge or a proposed increase in a rental charge is so excessive with due regard to all circumstances as to be harsh and unconscionable. The commission shall consider a number of the following circumstances as applicable to the type of accommodation. So the standard by which we review things is harsh and unconscionable. And the conditions we will look at with regard to a rental increase or rent being charged is any number of what the 13 items I'm about to read off, but just so that you know. The rent's charged for the same number of rooms and other housing accommodations in the same and in other areas of the municipality, Rocky Hill. The sanitary conditions existing in the housing accommodations in question. 3, the number of bathtubs or showers, flush water closets, kitchen sinks, and lavatory basins available to the occupants thereof. Number 4, services, furniture, furnishings, and equipment supplied therein. 5, the size and number of bedrooms contained therein. 6, repairs necessary to make such accommodations reasonably livable for the occupants accommodated therein. 7, the amount of taxes and overhead expenses thereof. 8, whether the accommodations are in compliance with the ordinances and general statutes of the state of Connecticut relating to health and safety. 9, the income of the petitioner and the availability of accommodations. 10, the availability of utilities. 11, damages done to the premises by the tenant caused by other than ordinary wear and tear. 12, the amount and frequency of increases in rental charges. And 13, whether and to the extent which the income from an increase in rental charges has been or will be reinvested in improvements to the accommodations. So those are generally the 13 categories of areas of inquiry that we look into with determining whether a rental increase or a rental charge is quote unquote harsh and unconscionable. So with that being said, we have a little different situation here today because we normally would have after the claimant presents their case through either individually or through counsel, There would be an opportunity for what we would have is essentially questioning by the respondent. We don't have that here today. So I just want to let you know that we do have this letter in the record that you've seen to it. You can choose whether you need to respond to it or want to respond to it. But it's your claim. I understand that you're represented by counsel. Is that correct? Yes. Oh, okay. So I thought so. I just wanted to be sure. So that being said, what we're going to do, you understand that the commissioners up here today have reviewed your packet. We thank you for submitting it. We've received the supplemental information and documentation as well. So be rest assured we have reviewed it, but we still may ask you to present your claim in this case, and we may have some questions. We certainly will have some questions as you go along. So that being said, I think Attorney Slater, if you could swear the witness first.
Planning to offer a witness?
Ms. Harper.
If she could come up to the podium?
Then I'll defer to you on how you want to present the case, counsel or Ms. Harper as well. Like after the swearing is, you. Go ahead.
Could you raise your right hand? Could you state your name and address for the record?
Keisha Harper. My address is 300 Cold Spring Road, apartment C609, Rocky Hill, 06067.
And you swear or affirm whatever the case may be, the information you provide tonight will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, I'll defer to Ms. Harper as well as your counsel on how you want to go ahead and present the case.
Sure. It's a little bit different than I expected, but I think if you don't mind, I'll just give a little statement.
That's fine. And then if you want to call her up as a witness, that's fine as well, or if we have questions. But if you can put your appearance in for the record.
Sure. Dahlia Romanow, Connecticut Fair Housing Center, counsel for the tenant.
Okay.
And just to confirm, you said that you also got the supplemental document that I sent over today? Okay.
Oh, no, last week.
Oh, no. Okay. So I sent over a supplemental document last week, and then I did just want to provide an update to the record if you'll accept evidence today, because I printed out the listing for this unit as of today. It is slightly different from when I had.
Okay, it'd just be a second. It's within, I think, the limits in terms of
Get a
quantity.
5-page.
Okay. So we said there's a certain date we set with regard to submissions, and under certain pages, we should accept it, and if not, such and such, we'll accept it. I think it's on the page that we don't know what's here, so I'll let you. Yeah, okay. All right, yes, good.
Thank you. Okay, so I brought plenty of copies here. Thank you. You're welcome. Do you need copies?
Yes, please.
The first 2 pages
Thank you.
are the listing as of today. You can see the timestamp on the top.
We just need one. We'll share if you don't mind. Thank you.
Yeah. And then I did also provide a couple of additional photos that Ms. Harper had sent to me. Okay. All right, so good evening. Can you hear me all right?
Yeah.
Okay. Good evening. Thank you for taking the time to hear this complaint this evening. Ms. Harper has been a tenant in good standing at this apartment since 2021. She filed this complaint because her landlord, at the time of making the complaint, was asking for a $250 rent increase from $1,634 to $1,885. As you know from reviewing the evidence, that number has changed several times, and I will get into that later. Ms. Harper is asking that the commission order her rent remain the same at $1,634 for the next year, which we understand may be an unusual request, but we do believe, given the specific circumstances, that the factors point to that result. To start, just to go over the history of what Concierge has asked for here, in September, initially they sent her a lease renewal offer indicating that they wanted an increase to $1,670. They then changed that to $1,760, presumably due to a clerical error. And after Ms. Harper attempted to negotiate that down, in December, they sent her another lease renewal offer, this time for $1,885, and that is when she filed this Fair Rent Commission complaint. They then sent her another offer at $1,813, and most recently in January, as you will see, they indicated that they would accept $1,700. So for the purposes of this hearing, I would ask that the commission order no increase beyond $1,700, since that seems to be the most recent amount that concierge has offered. Again, I know that asking for an increase of nothing is unusual. But first, I'll point to factor one, rents for
if I could
comparable
just
units. Yeah.
Clarify, just to be clear, you began your presentation by indicating you were asking for no rental increase, and then it seemed to be that you pivoted to 1,700. Did I misunderstand?
No, I apologize for any confusion. We are asking for no rental increase, but if you order a rental increase, we're asking that it not go beyond the 1,700.
Okay.
One thing that I'd like to clarify,
Sure.
I'm looking through the packet, and maybe I missed it, but do you have the initial offer of renewal from September in this packet? In writing?
Should be in the packet,
Okay,
yes.
Maybe I missed that one. With the clerical error, because yeah, there it is, renewal offer selected. So if, correct me if I'm wrong, did you respond to the renewal offer for 1670?
So the renewal offer for 1670 was changed within 1 minute via email. There was nothing for me to respond to.
You have to come up to the microphone because it's being recorded.
It's being.
So we need you to come up here.
It gets recorded, sorry. I should have told you that, my fault.
No worries. So as I stated previously, the offer for 1670 changed 1 minute later via email. I couldn't respond to it because they changed it immediately, and then it became 1760.
Just I jump in here. The term of your lease, when was your lease up? The written lease part.
I don't know offhand.
I
would have
believe
to-
the written lease was up in July.
Okay, so it is, keeps going. I didn't know if there was a change, because I saw July 2023 to July 2024. So right now, are you operating under a month-to-month?
Correct.
Okay, understood.
Okay, so from the history perspective then, let's walk through it for 1 second. So this offer was for 1670, was sent out, you received it, you have a copy of it. You weren't able to respond to it because immediately after they sent out an offer for what amount?
$1,760.
Okay. And so, and then they went up in price and now they're come back down to 1,700.
Yes, in January, correct.
Okay, and so, just to make sure if my math is right, the 1,700 represents just about a 4% raise in increase in rent, about, and then the 1,670 would represent about a 2% increase in rent,
Correct.
approximately?
Yes.
Okay,
But again, just to be clear, I wasn't able to receive the 1670 because that was an error on their behalf, they said.
which totally understand,
Yeah.
I wanted to make sure you had that in writing, and, because for some reason I had flipped past that one page. So that's why I was looking for it when you mentioned that.
It's via email, that's why.
Okay.
Go ahead. You might
Thank
want to
you.
sit over there, because we may have questions. We got an active bench up here, so.
All right, so to go to the factors, for factor one, rents for comparable units, we don't have to look very far because concierge, in fact, has directly comparable units listed. Ms. Harper lives in a unit which is considered the Bentley, which is a 900 square foot, 1 bed, 1 bath unit. You'll see in the evidence that I presented that currently the Bentley is listed on apartments.com for a range between $1,610 and $1,630 per month. That's the rent that they're asking for this unit, which is essentially what Ms. Harper is paying right now. She can also provide testimony, and you should see in your packet, I believe it's the last page, that she has a friend living in the building, also living in the Bentley, who was offered a lease renewal at $1,549. And she's not asking that her rent be decreased to that amount, but just to show that this comparable, in fact, identical apartment is going for no more than $1,630 right now. And that's what the market is indicating. I would also point to the amount and frequency of rent increases when she moved in 2021. Her rent was $1,249, and it's gone up 31% since then. Now she's paying $1,634. She had a $200 increase in 2022 and a $150 increase in 2023. So even though, again, I recognize that this is only a 4% increase, it is not in line with what concierge themselves are asking for this apartment. And it is an additional to some very significant rent increases that she has already had to pay. Sorry.
One
Yep.
quick question. With regard to the evidence that you said regarding the other individual that lives in also lives in the Bentley? Okay.
Yes.
When was that offer made?
Ms. Harper, do you
I can't
mind?
really pick up on that exactly, but from,
So his rent was renewed actually last year, like right before, while,
okay, it
I
says,
was-
I see that at the bottom of the page, says this offer will expire 12/15/2024.
correct, yeah.
Okay.
Okay, and just to confirm, his current rent beforehand was $1,515?
Correct, yes. And I also want to add, if I can, that I moved in before him, and I recommended that he move there, and my rent started off at $1,249, and I've surpassed him exponentially.
Did you raise any of these issues with anybody directly at management?
I have.
What about that in particular, about the fact that you had moved in before someone?
They just tell me that there's nothing that they can do to assist me, and that's out of their control anytime I try to speak to them, if I even can get a manager to speak to. But they've always informed me that it's not up to them.
Understood. So the other question I have is, I'd assume since your lease was up in July 2024, in terms of written lease, so there's different leases in which I'm very much aware of. You can have an oral lease as well as a written lease. In this particular case, it was up in July 2024. Given we've had other complaints or cases before this commission, so the commissioners pretty much know this pretty well, is that there's when a letter goes out giving an offer, it usually happened months before the termination of the lease. Do you know approximately when you received that first offer?
So in my case, I didn't receive an offer. I actually went to them.
Okay.
They didn't send me anything. They
Okay.
forgot, it seemed like.
When was that?
I went a month or 2 months before.
So probably May?
Yeah.
May? Okay.
Yeah.
And then after you went and talked, whether it be on the phone or in person?
It was in person.
In person. And did they make the offer then, or is when you left, they send that email that we
There
talked
was no offer that was made immediately, no.
Okay. So when did they send you that email that they quickly corrected or
It was in
changed?
September. By the time they recognized, it was in September. That was the first offer that I received.
So you had already finished the term of your written lease by the time they made the offer?
Correct.
So she was, and your lease has a provision for month-to-month, no. And so therefore, you're operating under the month-to-month portion of her lease at that point in time, correct?
Yes.
Okay, so,
Did they have the same, we've seen letters, I don't know, I might have skipped over it because you said it was in an email. I just don't have it. They've typically make an offer, of course, if it's done before the lease is up, we've seen that. But where they'll say, if you accept by this date, here's this price. And then if you accept at a later date, the price is a little bit higher. If you accept even at a later date or decide to go month to month, here's your price.
So I'm happy you asked that question, because I only received that for 2 years, but I never received offers the way that my friend did. So for instance, it says 6 months, 8 months, 12 months, 14 months. I only receive one offer. I don't receive what everyone else is receiving. So it says selected on the email, selected offer, but I didn't select any offer. They're only giving me whatever price it is, and for 12 months.
Okay, so yeah, what I meant is, I think we might be talking about two different things.
Okay.
You're talking about the term of your lease, like they're offering somebody a 6-month lease or a 10 or a 12-month lease.
With the different price.
Yeah, with different price. What I was talking about and what my experience has been is that if your lease is up in 4 months, a written offer will go out and say it's $1,000. And they say I'm just picking a number out. And then if you sign within the next 2 weeks, at 4 months out, it's $1,000. But if you wait, 3 months out or 2 months out, it goes up to, $1,100 or $100 or $1,200. Sort of in a way that they incentivize you to sign early so that you'll stay in the apartment.
Yeah.
Did you get anything of that nature?
Not last year, no. I didn't get anything like that.
Okay, I'm sorry, go on. Unless somebody else has any questions, but that's helpful. Thank you.
Thank you. Okay, so I just want to address the rest of the factors, namely factor 9, the renter's income and availability of other housing. Ms. Harper's monthly income is approximately $28.33 per month, so she's already paying about 58% of her income, and any increase would be a hardship in this situation. I would also like to address factor 7 and any factors that go to the landlord's expense, and just note that the landlord is not here. Concierge has not chosen to provide any evidence as to their expenses, and so I think the commission ought to assume that this is not a concern in this situation, again, particularly given that they are currently listing this unit at $1,630, which is what Ms. Harper is already paying. I would also just quickly flag on factor 2, sanitary conditions. Generally speaking, Ms. Harper's unit is in decent condition, but she has reported issues with common areas, including the front door not locking properly so that people who don't live in the unit or in the building can get into the building. And the fact that she does pay partially for a gym in the building, but in the gym, most of the equipment is broken. And Ms. Harper, do you want to just speak to that really quickly?
So in regards to the front door, I have brought it to their attention on several occasions that anyone can walk in, and that's what it is at the moment. There's a key fob that they installed, however, it doesn't close the door, you can open it. So oftentimes, even people that don't live there, they know like you can just go to the front door. The only door that works where you have to use the key fob is the back door, which I think is dangerous, and I have brought that to their awareness.
Could you speak to the equipment that is broken?
Yeah, so for instance, the Pilates equipment, that's broken. I went there one time to go to the gym because we're paying for it automatically, and that's not working. A lot of the equipment that it looks nice, but they're not working. There's one where there's like a wall you can climb, but it doesn't work. Yeah.
Okay.
All right, so I'll wrap this up and just reiterate what we're asking is that her rent remain the same in the circumstances, given the way that concierge has treated Ms. Harper with regard to this rent increase, the confusion, the fact that she's being asked for an increase that would take her above what concierge is asking for other tenants, above what her friend who lives in the building is paying, and presumably above what the market demands, again, given what concierge is listing this apartment for. We do believe that any increase would be harsh and unconscionable based on all of the factors. I would also just note quickly, if the commission would be willing in any order to also address the fact that the lease renewal offer indicates a $200 late fee, which we do consider to be a rental charge and therefore under the jurisdiction of the Fair Rent Commission. That is against Connecticut law. There is a new law in Connecticut which limits late fees to no more than $50. And so I understand if the commission doesn't want to address that in their decision, but we would appreciate a note indicating that Ms. Harper cannot be charged more than excuse me, more than the law legally allows them to.
Okay. Okay. Do you have anything else to add?
Yeah, and then the last thing I'd like to add is that I moved to the concierge due to the fact that in 2021, my rent was $1,249, which was fairly affordable. I thought that, and it was for 14 months, I thought that that would be something that I would be able to maintain, as in maybe went up by $75 or $100, but I never fathomed that my rent would go up by that much each year, that it would go up by that much. So I also wanted to just add that in.
Okay. Well, may I have some questions?
Yeah.
You moved in July 2021?
No, it was in February of 2021.
Oh, because you had a 14-month. So
But that was no longer offered to me when I asked them to like continue with the 14 months.
you've had 3 written leases, correct?
Correct, yes.
So 114 and 2 12s, 2 12-month leases.
Yes. mhm.
Okay. And how did they handle the rental increases? Well, let's take a step back. I'm assuming you had rental increases just by doing the rough math. What was the rental increase between your first written lease for 14 months and your second one?
So the first year, they actually tried to go up by $500. And I thought that that was ludicrous because I was like, whoa, I moved here because this is affordable. Why is it going up by this much? And so I actually proceeded to try to do what I'm doing today. But I was sent an eviction notice and I was frightened after getting many threats. And I felt like I just want to pay whatever they'll offer me. So if they can go down a little bit, then I would be willing to move forward with it. After us exchanging emails and going back and forth, they went down to $200. That I still found it to be extremely expensive, but at that point, I couldn't move. I couldn't afford to just pick up and leave. And so I just stuck with it. The next year, it went up by, and so that was after I actually entered in here, and whoever was here that day, they made me just sign off on the $200 because again, I was uncomfortable, and I was
So it went 200, the first increase is about $200.
Correct.
Which so that took you up to around 1,400.
yeah.
And then you had a subsequent increase, and you said you came in here and it was.
No, that was the first. So 2022, they were going back and forth with me. They were whoever their representative was kept calling me and just saying, you know, if you can't afford the $500, you need to just move out. And I was like, that's not normal. I've never heard of anyone's rent being increased by that much. And so that's when I began this process that I'm doing today. But I got an eviction notice, and I was extremely anxious and stressed out, and I was frightened that I would be put out. And I don't, to be homeless is scary. And so after going back and forth with her, whoever was representing the concierge, they didn't want to communicate via email. So I really don't even have any evidence. She only would call me, even though I would ask, can you please just respond to me via email as I'm doing with you? She didn't, so she called me one day and said, well, we'll do 300, and I said, I'm not willing to do that. And then she went down, she called me back and said, I can do 200, that's the lowest we can do. She was
And
like
that got you-
haggling me.
That got you to the 14, or is that?
That got me
you
to the
16?
14.
Okay. What happened after that?
And then after that, it went up by like 150, a little over like 150, close to that amount. And then again, I tried to speak with them. Like I said, hey, like I went up by 200 and I worked with you guys, instead of moving forward with the case, I didn't do that. Can you guys work with me? Again, it was different group of individuals. They have a fast turnaround rate at the office. It was different employees. And they said, same thing, there's nothing that we can do. And I was like, well, who can I speak to that owns this company? Like, who's the landlord? There's no information on anyone. I can never find anyone. And they would say, well, they handle that, and they'll just send me the amount. And honestly, at the time, I was dealing with my grandma's dementia as a caregiver. I just signed it. I really just didn't have time because I was handling that.
Understood.
So when this happened, I was like, this time I'm not going to be a coward, and I'm going to move forward with it because they keep going by. At this point, it's coming to an amount where I'm going to end up being pushed out. And in order to move, you have to have so many months of rent in advance. I'm not going to be able to afford to pay to move and then also have 3 months of rent in advance. So like this time, I knew I was going to move forward with the case.
Understood. Okay.
Yeah.
What's that?
I'm just a little confused, I'm sorry. I have a copy in here that says that you selected to accept the 1760.
And so that's what I was explaining earlier. They are making the selection. I don't make any selection because
Oh,
they're
they
not.
selected it for you?
Yeah, so that's,
Yeah.
so the page that,
Original offer and the secondary offer.
oh, so the page that the council was mentioning earlier, where I show you that my friend, he sent the screenshot of what he's being offered, I'm never offered that same breakdown. They're selecting their offer for me and just sending me that one offer.
So they're just selecting for you, renewal offer selected.
Exactly, but I've
Yeah.
never selected anything.
But at the same time period, if she has something that's written that says a renewal offer selected for your records, your term was selected for 12 months at a total of 1670, which is the email that we have in front of us.
Yes, but I didn't select anything again.
I understand that. I'm just saying that's what the written print says, is
Yeah.
selected.
Exactly, yeah.
Okay, thank you,
Then one after that says the 1760 selected.
Oh, I understand.
thank you.
Welcome.
Odd way of doing it.
Well, it's confusing.
In line with current practices that we've seen from them, so. I don't have any other questions. Does anyone else?
So I just have a quick question. So you've been essentially month to month since July?
Yes, and so what I
there's
was.
usually an increase in rent, correct?
Yeah. So I was just paying the $17.60 at the time of
Mm-hmm.
whatever they were offering me because, again, I'm trying to work with them. And so I was trying to get a hold of someone, and I could never get to anyone.
Okay.
And, by the time I got to a manager, it was like months later when I actually could see one and sit down. And they, again, said that, there's nothing we can do. So then the offer went from $1,813 to the $1,885.
I see that one, yeah.
Yeah.
Yeah, and I see that you've also been as current to rent as possible the whole time.
Yes.
Okay. Thank you.
Welcome.
Anyone?
Counsel? Do you have?
I don't have anything to add, but I would just also flag that I believe Ms. Harper may have been overcharged for the month of December. It's hard to know because concierge hasn't provided a breakdown, but she paid approximately $2,200, which is what she was charged, and that's more than $400, even going off of the $1,700.
Yeah, so
So, I mean, I guess without them here, I was hoping to be able to ask for an explanation of that. Without
that-
them here, I don't know if you can issue some sort of order just asking for an explanation, and if she has been overcharged, for her to get some sort of credit back.
And there's a December 2020, that's a December 2024 charge that would have otherwise been paid in January, correct? Was it paid in January?
No, that was all paid in December.
Was it,
Is
Yeah,
it this
so-
charge that says 466.92?
Yes, that's the.
It says December 9th,
That's the additional,
1760.
so
Okay.
altogether, it's over $2,000 that I paid.
So one of the other things I noticed actually in your friend's renewal, not
a late
offer,
fee.
not yours, is that there's a column for other charges. Is that what this was an other charge?
I'm sorry, I don't
So-
understand the
so,
question.
If you take a look at what you sent in. Okay, so you have the lease rate in the left-hand column, and in the middle column is an other charges for that they do base rent plus charges. So is the fee that you paid in December an other charge?
Sorry, one moment.
Yeah, no problem.
It's right here in the,
So the other charges, are you asking me what that is?
Yes.
Other charges, what I was explained when I asked them what that is simply that's supposed to take care of the cameras that are on the premises that don't work. They only work outside and in the lobby. And there's nothing in the elevators, et cetera. And then it's also supposed to take care of the trash removal, is what I was informed.
So basically, other fees on top of your lease,
Correct.
the
So-
CAM charges.
CAM charges.
But I asked them isn't that supposed to be also included in it? So I was told yes at one point, and another time I was told no.
Well, there's two different practices, just from a real estate perspective. One is to break out the CAM charges and separate them from the lease, and the second one is just roll them in. So, looking at the language of your lease, it basically says that everything else that's provided is a no. And so that's where they come with that charge, so.
There is it's at around the same point in the packet that you submitted, but it's the same issue, is that you show a payment of $466.92, and that's the issue that you think that you may have overpaid. Let me ask you a question. Why did you pay it in the middle of the month?
So I wouldn't receive an eviction notice.
What did they generate to say that you owed $466? Look it up.
I'm not
I'm
sure.
sorry, so I got a payment receipt that says $466.87, or $466.92, because there was a convenience fee. What prompted you to make that payment? I know, understand that you said that, aside from that, you didn't want to get an eviction notice, but they had to have communicated something to you to say, this is a charge for something.
Oh, I just received the email, or like the reminder that you have an outstanding balance. So I still paid the $17.60, trying to reason with them. That's where we were at. And then the remaining balance was the $400, whatever the amount is that you said.
Okay. So
But, yeah,
after your rent, your original lease was up in July 2024. Up until that point, you had been paying $1,600 and,
it varies.
yeah, about $1,600 and change. Immediately after, so I would say that when your rent came due in August 2024, you started to pay $1,760, correct?
Let me look, because it varies. There was like 1 month where I did pay, it varied. If you look at the picture of my checkbook, there was 1 month where I paid 18 something, like every month it would just change.
How? What do you mean, how? Like, because they would generate a bill to you or an
They would
invoice?
Yeah, they would generate a bill, and I would ask them, like, isn't the rent supposed to be,
$1,760.
$16.30? No, this is before it even broke. Isn't it supposed to be $16.34? And they would say, well, there's different, it changes every month. The trash amount would change, and so it would vary. So there's 1 month, if you look at my checkbook that I sent a picture of, I paid 18.
34.47?
Yeah. So
Okay.
Yeah,
it's not consistent.
So I think it probably falls into the CAM area maintenance expense addendum,
Yep.
which,
CAM charges, yep.
which unfortunately they don't break down, and we don't have an accounting as to that. What you've paid for goes to really maintaining the things in the good operating working order, which is what the CAM addendum says that it should be doing. And so you're basically pointing to the fact that several of the things that should be working, which include the security cameras and the exercise equipment, as well as the front door security, are non-functional.
Correct.
Thank you.
Thank you.
So, one of the things, what we typically do, and before I get there, I want to sort of explain the next step, is we would normally have a back and forth. They put on a witness, they may ask you questions, they may not, they may have their own witness, and we may basically just go to closing arguments or summation. What our commission then does is we close the public portion of the hearing down, and we just, for public comment comment from the claimant and respondent and their counsel, and what we do is we deliberate on the record. So you see it happen before your eyes, which can be good or bad, depending on the situation, but it's more or less you can see the thought process there. But you're not allowed to present any more evidence or any other testimony at that point in time. So before we get into that, I just want to kind of just air out a few things to give you an opportunity to address it. I'm struggling with the ask, because typically the way we handle complaints in the town takes them in is they'll ask, because we've had some troubles in the past, in years past, where people haven't really articulated what the requested relief or what they're trying to get, and we've had hours and hours and hours of testimony only to find out that it's completely different than what we had reviewed the record for. Going into this, the ask of the commission, I saw down, it was that the rent remains at $16.34 amid, and that no increase is applied with the renewal of your lease. The hedging or the alternative 1,700, I don't have a problem with that. My issue, what I'm struggling with, is the keeping the case open regarding the 486. It's because I don't understand. The other side didn't have an opportunity to respond to that. I'm not saying that that's not valid. I just don't think it's ripe, if you will, before this commission yet, because it's not part of the ask. It's not saying that your claim is wrong or going to be defeated or will prevail. It's just that there's a point in time where it fixes the scope of our review is when we receive the packet and we look at it saying this has to do with the rental increase, not because of a claim charge.
The one thing I would interrupt that with is the late fee that they're attempting to apply.
I agree.
Is something part of this because of the fact that the renewal?
No, I mean, I wouldn't say it's a part of this. I think it's a valid issue, but I don't know that that is something that you have to do, I believe, in housing court.
Yeah, that hasn't been charged yet either, has it?
The 200?
No. I was just asking if you're able to make an order regarding the
Prospectively,
lease
yeah.
term.
Yeah, and what I'd suggest is, there can be advisory rulings sometimes like a court can do. It's really not where you have authority to just give advice. If they do something incorrectly in the future, then remedy counsel could either bring whatever remedy that statute provides for or possibly another complaint. But as of right now, my view, the thing that's before the commission is just whether or not the requested amount is harsh and unconscionable under the factors of the statute.
Okay, so just one point to clarify, because I want to make sure to understand this, is this a late fee for rent or late fee for signing the lease?
This is in the lease, it says it's a late fee for rent.
Okay, then, yeah, that's something that should be in housing court and.
Yeah. And what I was trying to say is with regard to the 486 or
Yeah.
that number.
Sure.
The 466, I'm sorry. That amount, and again, I'm not giving a ruling on it, it's just that there's a certain point in time that the scope of the claim is fixed, and we conduct our due diligence in reviewing it, as well as the other side makes the determination of whether they want to oppose it, want to show up or present evidence. If the claim changes somewhere mid-hearing, while that poses some risk for not attending, I don't think that's proper. I just can't, I don't think we can really decide it, and I think that the scope of our deliberations are just going to have to focus on the initial ask, which is the rental increase itself.
Sure.
So-
No, understood. That makes sense, given that they aren't here. So, and I can reach out to them directly too, just to get an explanation
Okay.
that way.
And you're represented by counsel, very capable counsel, so I would definitely try to address that and get some clarification on that, because if stranger things have happened, because if it's a charge that it was improper and you're under the gun, you have to pay it because you don't want to be on the streets right before the holidays. I understand that, but you deserve some clarification on that. So,
Thank you.
absolutely.
My only concern about that, so my question is if I could be credited then, because they're not going to explain it. That day when I paid it, I asked the receptionist, why am I paying, so much more? And she said, you would have to speak to the leasing manager or the assistant manager. And I then said, okay, so can I speak with them? They're not available to speak to anyone. That's literally the line that I'm consistently told, which is why this has been drawn out. They've only recently began to respond to me and call me every day prior to receiving the packet because of the fact that I moved forward with this hearing.
Well, what we could do is that you're represented by counsel.
Yeah.
So I'm sure that she's more than capable of getting their attention. But I would ask, again, I'm not weighing on the
No, I understand.
one way or the other. Maybe, after this hearing at some point during the week, our staff will be reaching out to them to let them know what our decision is. If they're not watching it live right now, we could ask them and say that's going, sort of tee up the issue that you or your counsel will be reaching out to them directly to see if we can find out clarification of the charge, what those charges are for, and that we would all appreciate a better understanding of what that is.
Okay, thank you.
Okay, you're welcome. Is there anything else? Okay. At this time, we're going to entertain a motion to close the testimony portion of the hearing, and then we can go into our deliberation phase.
Motion to close.
Seconded?
Second. All those in favor?
Aye.
Okay, the ayes have it. All right, we're closed. So with regard to the deliberation, just again, to set the table, for the scope of what we're reviewing, again, it has to do with the rental increase and the rental increase only, under the standard of harsh and unconscionable, as well as the factors that have been discussed at the beginning of this hearing. Some initial thoughts on my end is I think we have to take recognition of the fact that we've had claims in the past where they're in the middle of their lease, or they've signed a lease, and there's been some issues, health issues or other issues with regard to the accommodations that we've had to address both retroactively and prospectively. I'm troubled on this situation because we're in a lease right now, which is a month to month. So the term is month to month, but it's of the lease. So the terms can change up or down month to month as long as I notice right now. So it's not necessarily governed by the written release that we had here before. So it's a bit of a struggle in terms of prospective release. I don't know that this commission, and I'm pretty positive that this commission cannot award or issue an order to force two parties to enter into a written contract. It's not within our jurisdiction to do so. We can deal with conditions that need to be addressed during the pendency of your claim or up into or covering the period of your claim, but this commission is of limited authority. It is what it is. It's a creature of statute. We wouldn't be here without that, but they don't give they have a limited charge. We're not rent control, so we can't do that, and we cannot issue an order requiring them to enter a contract with your client or directly Ms. Harper. We can't enter them. It's not my thought that we can force them to do a 12-month lease with you at a certain terms. They're just not allowed to do that. And that's where my struggle is in doing this. In terms of the rental increase, it's gone up, gone down. I mean, part of my thoughts is I do want to take some notice of the history of this apartment complex in this town and some of the hearings beforehand. It's very disappointing that they didn't or were not able to attend today because I would have had some questions, but I also do take notice of the fact that historically, we've had testimony from both sides, both claimant and respondent, involving concierge claims, where they've indicated that other tenants had received different offers for the same apartment. And we've heard testimony where that has been the case to incentivize them to sign up, to get people fill vacancies, and there's economic reasons to get somebody to come in. That I understand. So sometimes it's almost like a loss leader to get that vacant apartment filled and filled right away. So I understand why a general advertisement may be less than the current amount that current tenants are paying. That's the way they do it. We've had testimony in that regard. So I understand that. With regard to the other tenant, and I do appreciate, this is one of the few times that we've actually had testimony about another individual that's actually in there in proof of what they're paying and what they've been offered. Some of that could be it started off because that tenant could have gotten there later and had probably more favorable terms. And then the increases tend to be a percentage or an amount of that person's current rent. So since they start at a later date, the base is lower. The increases don't typically catch up. I'm not sure that's the greatest way of doing business, but in any event, I do have a struggle. We can't force them to contract for a 12-year lease. We just can't do that.
12 months.
12 months, sorry, 12 months. Freudian slip there. So those are just my initial thoughts. I'll open it up to any of the other commissioners.
That was going to be my question to you. It's almost like we're being asked to negotiate a lease on behalf of somebody because there is no real lease, correct? I mean, we're month to month, but even the month-to-month fee that she's paying, I'm not sure where that came from. It's one of the numbers they gave to her, but not,
Yeah, let's talk about this for a second, because I want to make sure that I understand this a little bit better and make sure that we're all on the same page. Okay, so she's had previous rent raises that appear to be out of line with what is a harsh and unconscionable amount of increase. So like the amount of increase is something, from what I understand from our charter, is something we could look at. So we can say, hey, look, if they're trying to raise the rent by $300, we could intervene at that point. Is that inside or outside of our charter?
his rent control.
Any rent that's been established, if there's a challenge to this commission, the commission evaluates the various criteria that the chair had mentioned to decide whether it's harsh and unconscionable. And you can make a determination that an amount being charged is harsh and unconscionable.
Right, and so
So
the
to
reason.
split the hairs, I think this will answer it. I think that if we're in a situation where someone signed a lease for $2,000 and it's for the next 12 months.
Yep.
And that claim came before us, and whether then, after signing that, they say, I signed it, it's too much based on these rental conditions, then I think since they're already in a contract, in a lease term, that's something we would have the power to address. But the rent here is, the term is a month, I believe, since it's month to month. We can't, sorry.
Here's
Yes.
my other question, so just tossing this around, and I'm just thinking, and I could be way off base, but usually a month-to-month lease, which is just a carryover essentially, right? There's nothing signed, there's nothing agreed, just month-to-month, you're just going based upon your previous written lease. So truthfully, shouldn't the month-to-month rent that she's paying right now as a month-to-month, shouldn't it be the same as what her lease amount that she had signed was?
It all depends, and I'll have to take a look at the clauses that, like,
Okay,
but you can put in a clause that says, if the lease is not renewed by the date of the end of this lease and you proceed to month, the charge would be X plus, current rate plus an additional amount. So,
which I'm doubting it
holdover rent?
says, because there had been so many numbers that were tossed out, right?
yeah, and so,
Let's find that.
yeah, let's just take a look for that in the lease. And so typically, that's how the amount would change. And so if they don't have a provision like that, technically, the lease, the last written contract is what takes, it remains in effect.
Right, which would be the 1634, correct?
Unless they
Unless it's,
communicated another,
Well, the one thing you're not the housing court, you're not enforcing contract law or lease law. It's
We're out of
really
that.
the factors, whether or not what she's being charged. You can look at a month to month. There's nothing in the statute that says that it only applies to written leases of a certain term. So if the amount that she's being charged right now is harsh and unconscionable, that would be ripe. But I understand your point about getting involved and trying to negotiate, you know, what a 12-month, what
Yeah,
a
I don't think
12-month
we should
lease
be
should
doing
look like.
Now, one thing is
I
that.
think this is the most recent one, 1634. Increases, lease contract changes. But actually, so what I just brought up is irrelevant anyway, correct? For us here? Like the month-to-month carrying price.
I think it's paragraph 15.
Right, so we can
page-
just cancel looking
Paragraph
through.
15, page 207 on the lease, under rent increases and lease contract changes. At least it's in bold,
Oh, rent
so.
increases, okay. At least 5 days per.
They automatically continues. So should,
Yeah, but we can't negotiate that, I
oh,
guess.
I understand that. This is just kind of a point of
I was just
clarity.
curious, it just hit me, that's why I brought it up. I'm sorry that
So,
I,
so
muddied
per
water.
per this, there technically shouldn't be an upcharge, but
Correct.
yeah. So the contractual nature of really what's happening, which is they're trying to enter into a new lease, and both sides need to agree to a rent level. There is, it is tenancy at will still in this state at this point in time. And so if a lease term does expire, somebody can get evicted, and correct me if I'm wrong on this one, can get evicted for expiration of lease with appropriate notice and appropriate due clause, which is not what we're talking about here, but what they basically have threatened her with.
That's correct.
Okay? So to that end, right now, they have appeared to come back to the negotiating table where the rate was drastically higher. And they've come back with what is a 4% approximate rent increase at this point in time is what the offer that they put on the table. From what I understand.
Yep.
The thing that makes me least comfortable is the fact that they also have a different amount that they sent her in writing for a rent agreement, which is the 1670. So even if you sent a contract in error with the wrong amount, if it's a contract in error and the person has a copy of it, and it says it's been selected, is that enforceable?
Again, you're not a housing court to enforce whether a contract exists or not. From what I heard, the witness indicated she wouldn't have an opportunity to even accept the offer because within a minute, the revised offer came in, so.
Yeah, so just making sure that, to talk it through. So from what I really understand at this point in time, there's a contract that's in effect right now, which should, if there's an issue with that contract and its enforcement, should be brought up to the housing court. There's a current offer that's in effect that represents a 4% raise in pricing. So I don't see anything that unfortunately is actionable at this point for us to do.
I tend to agree. I mean,
Well, unless, like you said, if we can enforce the 30-day, because it's still a lease, right? So our job would be to say, okay, she's paid $1,760, but really she should have been paying $1,634 because this just carried over, correct?
We could actually,
No?
Well, frankly, all of these numbers, we don't know what the market is, and we don't know what, all the factors are. So it's possible, I'm just talking in hypotheticals here, it's possible that Concierge is offering such an unbelievably low rates in the market that even the increase wouldn't pass muster under the various criteria. And one factor is ability to pay. You heard some statements regarding ability to pay, which could factor into all of that. But in enforcing the specific requirements of saying that she's being overcharged, that they're not getting appropriate credits, those kinds of things is not what you do. So it's really a matter of deciding whether what she's being charged now is harsh and unconscionable, or to find things are really not ripe with respect to the 12-month lease.
and the one thing that's in line with that is, frankly, there hasn't been a loss of use of the property, basically no health conditions that were mentioned, nothing that would be any of the other criteria we've talked about.
yeah, and I understand the concern about where you moved in, and I feel for a lot of people have been in the situation that they've seen the prices increase through COVID and the massive inflation, particularly with housing. Housing has been, we've seen that here, we've seen it with people that have single-family homes, apartments, the like. We've had massive amounts of inflation and price increases throughout the year. I mean, throughout the last 3 or 4 years. So while I'm still not happy about it, I've seen it. It's not uncommon to see something go up $200 or $300. We've seen that happen. before with claims here. We've all seen that with our homes and property insurance as well, but I do applaud this claimant for not, for essentially being a squeaky wheel in this, and trying to negotiate and get a good deal and try to mitigate whatever increase that she was faced with, and at that one time, the $500 increase, and able to get it down to a more reasonable number. So I applaud her self-help in that regard. But at this time, we're looking at an increase. It's a bit odd because I think that's the claimant sort of introduced it into the record about the back and forth in terms of the offers and where their last were, at least as of January 14th, 2025, of $1,700. And if you did the quick math, I think you said it was about a 4% increase.
Yeah, they're
Ballpark. And it's not disputed, at least in the document that we received from the respondent. It's just difficult to do so under the harsh and unconscionable standard to find, I think, in my opinion, to find that increase, as a word, it's now falls in that condition. I mean, it's just, that's the level of scrutiny that we have
That's right.
in review. So, does anybody else have any other comments? Okay. With that, I guess what we do is, just to frame the motion, I think we would need to have it ask if whether the claimant has asked that the rent remain at 1634. Actually, I'm trying to do this probably a little more efficiently. Do we? I think we need to find out that whether the current rent being charged is whether it is determined to be harsh and unconscionable under standards. If after that vote it's in the affirmative, then we go to the next issue, what the rent should be. If it's in the negative, then the inquiry ends there. So I guess I'd entertain a motion as to whether, somebody make a motion whether the rent being currently charged to the claimant is viewed by this commission as harsh and unconscionable. So I can't make the motion. I'm trying to come
Yeah,
chair, so I'm gonna,
I put a motion in to discuss whether or not the claimant's,
or to vote on it, yeah.
to vote on the claimant's current rent, if it's harsh and unconscionable.
Okay. I second the motion.
Second. Okay, any discussion, friendly amendments? Hearing none, all those indicating by, that say that in a positive, in favor of saying that whether the motion, whether the rent being currently charged is harsh and unconscionable, say yay. All those? Hearing it, those feeling, I guess that's, and those say that it's not harsh and unconscionable, nay.
Nay.
Okay. All right, the nays have it. So there's no finding of a harsh unconscionability. I'd also want to just note that both counsel and the claimant in this case, probably the most professional, well-spoken, and prepared individuals we've ever had before this commission in a long time, so I do applaud that. I would urge you to continue to have discussions with the respondent and see if you can work something out. It seems like there is some middle ground and ability to do so, and have further discussions. I think the claimant has a really capable attorney and may be able to get a response from them. I would also request our staff, fantastic staff at Town of Rocky Hill, in communicating our decision to the respondent, I would ask, I think it's helpful for all parties concerned that they get back to this respondent regarding this claimant, both with regard to the term of the lease, see if they can work something out, and also regarding those charges and an explanation, because I think it's in everybody's interest that gets resolved, and it shouldn't require a hearing to get those type of answers in response. She deserves better. So with that, we do have another agenda point in the motion for approval of the proposed meeting dates. Everybody's received in their agenda packet the 2025 Fair Rent Commission dates. There's a meeting date on the left-hand column, application date on the right-hand column. Application date determines whether it could be eligible for the agenda on the meeting date. So with that, everybody's reviewed it. I'd entertain a motion.
I move to accept the the proposed commission dates for the Fair Housing Committee,
Fair Rent Commission, yep.
Fair Rent Commission for the calendar year 2025.
Second.
Okay, any discussion? Hearing none. All those in favor?
Aye.
Aye, the ayes have it. So those meeting dates are approved. Thank you, Kelly and town staff. Appreciate that. So we don't have any other business items on the agenda. Entertain a motion to adjourn.
Motion to adjourn.
Seconded.
All those in favor?
Aye.
We're adjourned. Thank you, we're off the record.